Hello everyone, welcome to Court with Krissy. If only Judge Rossi had an unredacted police report that he could read on the record, I think it would prove that the respondent is a little bit cray. I hope you like it. Court with Krissy is now in session.
Motion by the respondent, Ms. Fry, to reconsider the decision of Judge Lieber in November last year, keeping this order in place. So, as a preliminary matter, Mr. Van Heuvel, would you place your appearance on the record?
I will. Attorney Justin Van Heuvel Law, on behalf of the respondent in this matter, Jara D. Fry.
All right. And Ms. Smith, would you state and spell your full name for the record, please?
Yes, it's Tiani Beck, Tiani, and then Beck, Beck.
Very good. And I'm sorry, I had you as Tiani Smith on my screen, but we can fix that, I guess. So, very good. All right. Well, Mr. Van Heuvel, this is your motion. I did read the transcript from Judge Lieber's hearing, and it appeared to me that he might have been on the verge of granting it and then kind of changed his mind and went the other direction and found the two occurrences. So, however, the motion to overturn, of course, his ruling is pretty high. I've got to find palpable error or something else, that was would have misled him. How can I find that?
So, Your Honor, you're citing to MCR 2.119F and that palpable error standard for a motion for reconsideration. In that section of the code, there's also easily perceptible mistake. And I think you've pointed to that by saying the judge, it looked like he was going to grant your motion and they went a different way. I think where that easily perceptible mistake happened, if we will, is the idea that there was two, contacts here. And I think that came through the false testimony that somehow my client that there was an open police report or anything. Now we know for certain the police report has closed, and in fact, as of 1/8/25, AP Slotsma denied any charges against my client. So this is a concluded matter, and I think that is a palpable error or easily perceptible change here that allows us to talk about why this PPO needs to be dismissed. Specifically, the source of texting just isn't my client. She blocked the number. How do you both block the number and then you're blocking the number that's doing this illegal contact? It's not you. That's number one, and I think that was clear through the transcript of the prior hearing. When we look at the statute for a PPO, there must be reasonable cause to find either two or more unwanted contacts or a pattern of harassment, right? Pattern. There isn't a pattern here because there aren't contacts. And that's why this just doesn't meet the law. This is just, in fact, actually the petitioner's had multiple contacts using third parties, herself, try to get my client fired from her job, gone on and done all sorts of irrelevant things. But what's relevant to this case is the police report is clear, not my client. They denied any charges. So at this point,
the police report appears to conclude that it was your client, but nonetheless, and I've got a heavily redacted copy of the police report that I read through, and it sounded like whoever investigated it did tie it back to your client. However, the prosecutor decided not to charge, and I could have been for, of course, their standard there is, they need to make a probable cause standard. I only need to find a preponderance of the evidence that they occurred. So my standard's a little bit lower on the civil proofs here. And I did note the one thing, it didn't look like, all we heard was the kind of police report itself, and then it sounded like perhaps the testimony of Miss Beck stating, hey, the police officer said he was pretty sure it was your client, and then that it was Miss Fry, and then later there, we never heard from the police officer. In other words, we never heard from the source of the information, how he came to that conclusion or why. So, yeah, that was a little bit of a mystery to me.
Oh, yeah, exactly, Your Honor. The way I read the report, it ties it back to a tower, but remember, these parties live within 3 miles of each other. And it's Verizon, a common carrier. I mean, that's like saying, well, I know that it's probably you because you're both in the same general vicinity. I mean, that's not, I don't think I think that's why charges were denied. It's not conclusive. And what I think tips the scale here is my client blocked this number. I mean, it tried to reach out to her too, and she's like, nope. So this is one of these things where, and again, what is really relevant here is that this petitioner has a history of contacting my client and trying to harass her at work. So this isn't the first time that this kind of conduct has come up, and my client didn't retaliate then, hasn't retaliated now, and it just goes on and on. Now, this time trying to take her rights away because knowing that her son's at the same Kentwood school where she works. I mean, this just keeps escalating, and it needs to stop. My client doesn't need to be harassed, have her rights taken away, anything else. If anything, this petitioner needs to have a PPO against her.
Well, has your client applied for a PPO?
She has not, Your Honor, because again, that just escalates the matter. And she just wants no contact. Block her phone, not talk to her, I mean, she's had no contact. None.
My children attend the school, so I don't want to prohibit myself from being able to engage in their education. I have to enroll my son, who's in middle school right now, in the freshman campus at East Kentwood, and I can't do that. I mean, I'm terrified just to go on the campus and pick up my children from school. This is significantly impacting me. And Ms. Beck has done several things to me, which she failed to mention in her request of her police report. The first contact that she mentioned, where I reached out to the school and filed a complaint, that was in regards to her behavior that was affecting my child. She was very upset that I was dating her ex-husband, and she made contact with my son at work and harassed him at work. And then she used information that she had access to and spoke to some football coaches in regards to that. And my son got backlash at school and on the football field, and I picked him up crying. So after speaking with the coach suggested that I reach out to the principal and talk to the principal about the situation, because her personal feelings towards me and Ryan dating were carrying over into her professional atmosphere at work and affecting my son. That's all I did with that.
Asking for no contact, right?
I was communicating with the principal that I felt concerned that her personal feelings were carrying over and affecting my son at school. And she then retaliated, contacted my ex-boyfriend, who I had requested a PPO against, and they conspired to formulate this little plan to call my job and file complaint after complaint after complaint until they eventually got me fired, which I have since fought for my job, and I've won through the National Labor Relations Board and the EEOB.
And where was that employment at?
Consumers Energy, and I worked there for 17 years. And I held the Local 107's union vice president position. My integrity with my company was very important, and she diminished that. I mean, I had a long-standing positive reputation there, 17 years.
Again, Your Honor, she didn't file a PPO because of her contact with her son. She didn't escalate. She just took appropriate measure to ask for appropriate guidelines. Again, she didn't call the school and say, have this woman fired. Nope. Again, appropriate contact, not escalation of matters. And all we get in return is attempts to fire my client, PPOs that are false, on and on and on and on. My client's rights should not be impinged because of this woman. They just shouldn't.
All right. Well, let me hear what is your response, Ms. Beck. Well, let me swear you in, Ms. Beck, since you're testifying as a witness, and I probably let me do that with Ms. Fry. Kind of in retrospect here, Ms. Fry, if you'd raise your right hand, do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, sir.
Very good. And everything you said previously meets that same standard. You didn't lie or say anything before I swore you in.
No, sir.
All right, Ms. Beck, what's your statement? Or let me swear you in first. If you'd raise your right hand, do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
I do.
Very good. What's your uh, response to the arguments made by Ms. Fry?
So, Your Honor, I did give you the statements like from her job contacting me. I did not contact her job. Also, from her and from her ex-boyfriend, I did not contact him. I didn't even know who he is. He contacted me. My responses back were, I'm not going to make a complaint. She'll get what she deserves over time. I'm better than this. My other response was, I don't have any proof she did anything. I did not contact her employer. They contacted me. They wanted to know everything about mine and Jara's relationship. I told them that I didn't even really know her other than it was my son's best friend's mom. She's now dating my ex-husband. That was it.
We have a copy of these? Were they submitted to the court and opposing
I
counsel?
submitted them to the judge, yes.
All right, Judge, we don't have a copy of those.
Okay, well, and I did see those. They were in the packet of information. However, they're not, particularly relevant to the current because they kind of relate to the past situation with consumers, which is, as I see it, isn't really um, the signature issue here. The question here is these text now messages and where did they come from, and uh, can those be utilized as a basis for a PPO against Miss Fry? So, and what about those text messages, Miss Beck?
So the text messages I got on August 21st, and they state, next time you wake up in the middle of the night for no reason, know that there's a really good chance that someone is watching you. P.S. I know what you did and soon everyone else will too. I tell whoever this is texting me, you don't know who this is, please stop contacting me. And then I get like all these riddles. I tell them, you have the wrong number. Who do you think that you're talking to? And then they say TRB with a wink face. And
Which are your initials?
yeah, those are my initials. Yes.
As
And
if they know who they're sending the message to. And I guess the question is, I've heard a little bit about, well, someone's ex-boyfriend. I don't know. I mean, is there anyone else, that has sent you or would send you messages like that, that you can think of that would do that?
no, and Miss Fry's, like when I got told from the detective that her name was brought up, and then like my mouth dropped because I was like, you've got to be kidding me. She's already came after me at work once. And then here we are a year later, and then I'm getting messages from her, well, who we thought was who they're from. And in the police report, it ties it to her using the same IP address, everything. It says when the account was open, August 14th through the 27th. And then it says on the 27th, that text now account was closed. And then Jara says that the number texted her, but the number didn't text her. It called her for a 20-second call.
No, that was the police officer that called the text now number. I received a text message with a text link. And I
In the
blocked it.
report, it does say that the number called her phone. That's how they linked it to her number. It wasn't a text.
Yeah, and and I do have to say, it was unclear to me. It was quite clear that the police officer had some reason to connect that number to Miss Fry. It was not clear to me how he came to that conclusion, because the report was so heavily redacted. And secondarily, what did occur to me is I have heard of text now, and that it's kind of an anonymous texting app where you can text from a different originating number, and comes up used in quite a few cases. And then secondarily, the You know, I did see the email account. It was a Proton Mail account, which I don't know is, as far as I know, a very secure but anonymous type of, they utilize those similar to text now, I perceive, and that it's a very secure, and I also don't know if they use, a VPN or something like that changes around and hops around IP addresses. All that stuff is unclear to me, and it was not, if it was in the report, it was in the redacted portions of the report. So I couldn't come to a conclusion there. All right.
Your Honor, if I
Yeah,
may,
go ahead, Mr. Van Huel.
my client has information on the Proton account that's associated with that text now. It's, she believes, based on its last, remind me,
So when the officer asked me about it, he said, did I know someone named R. Fillmore? And Fillmore, it didn't sound, I didn't know anybody with that last name. When I was able to get this full report and the email address was unredacted and I could clearly see it, RP Fillmore, it's actually looks to me like Rand Philip Morrison made an email, which would have been my ex-boyfriend and also the individual that Tiani was conversing with when the complaint was filed against me at my employer. So I would assume that, and it's just my personal feelings, that the two of them are involved again. Also, Miss Beck's son, Eli, had access to devices from my home. He actually lived in my home from June through December. And
Your Honor, he didn't live there in December.
And he was actually removed from my home because I caught him on security stealing from me. So I have no idea if he returned home with the device that I gave him to use while he was residing in my home. I cannot find that device, but I can tell you that it would have been able to sign into my Wi-Fi automatically had they come down my street. I can also tell you that on August 13th, I was nowhere near my home with my phone. I was in Muskegon at Michigan's Adventure with my children. On August 14th was my son's birthday. We left our home very early in the morning. I took my son out to breakfast. I took my two boys out to get massages, and we spent the day shopping.
where?
So there's in Granville. So there is absolutely no way from August 13th to the 14th, I could have even been on the same Wi-Fi with my device. Miss Beck lives about a half a mile from me. Now I can imagine that she probably pings off of the same cell phone tower. And if she was able to get her hands on that device, then she could have simply created that email and sent those texts. The very first texts that were sent off that email, according to the officer, were to me. At first, he told me that an email was sent to me with an email address, or a text, I'm sorry. I remember getting that link in the morning and I blocked it. He said that the next text was sent from me saying boo. So I pulled my cell phone record and I provided a copy of it to the officer. And there was only one text received by me, no outgoing text from me. And the officer said to me, I'm sorry, I looked at that wrong. Both texts were sent to you. So the text that initiated off that text now account, they were attempting to start engaging me in conversation first, which I completely ignored and blocked. After that, I have nothing to do with that phone number.
All right. Well, let me get a response. Ms. Beck, you wanted to say something additional?
Yes, please. Your Honor, Detective Davis did send me a message on January 8th and he had said, like, sounds good. Sorry, this one took so long. Multiple search warrants later, it appears she did create the account because it's showing that her phone, when he issued the search warrant for her Verizon number and the text now that it's linked together.
That's not in the police report. Your
It
Honor.
is in the police report, what I sent to your
Okay.
honor. And I don't talk to this Rand. I don't know who this man is. And the only time I talked to him were those messages that you see there that I submitted to the court.
Which were quite a bit older. Those were 2023 messages.
Yeah, and I don't know
not,
who this,
not the same time frame.
No.
Okay. Well, I did, I did, like I say, I reviewed that police report and I mean, what would obviously be the decisive thing would here be if we could hear from the officer and his, now my next question to you, Mr. Beck, a little more practical here. You know, Miss Fry is indicating that this is impinging her ability to go to her kids' school activities. I mean, if she dropped her kids off, I saw that you were an administrative assistant. I take it you probably would not see her there at the drop-off point, or is that wrong?
No, I would not see her because she drops her kid off at Pinewood and picks him up at Pinewood. And I know for a fact that she's been going to her sons, both sons' wrestling matches and been going to everything that they have at the school. And they're not at my school. I'm at the freshman campus, not at the high school, not at Pinewood.
Your Honor, Tiana's admitting that she's following my client.
I am not admitting that. It's been reported by Kentwood Public Schools where if she shows up at an event, I know about it. They let me know. Other than that, like I have no reason to go to wrestling at all. And I was there to pick up my son at the last middle school event that she had went to. I was there to pick my son up from anime club.
I mean, so you do have kids that are in the same grade at the same school, and there is a
Yes.
possibility you could overlap, but your kids doesn't sound like they do the same activities.
No.
Well,
Anime club's pretty far from wrestling. All right.
Well,
Well,
my middle schooler is going to be attending the freshman campus next year. We actually have an enrollment date in about a week where I have to actually go to the East Kentwood freshman campus to enroll him. There's going to be activities there that he needs to attend for next year's freshman. He'll be a freshman. I
Sure.
can't do these things because of what she has in place. And
all right. Well, what I'm going to do here is, you know, like Judge Lieber, I've kind of heard a recitation of the testimony, and I am equally, in a position where, what's clear to me is there are not, great feelings between the petitioner and respondent. There were these inexplicable texts. They do contain her, that is the petitioner's initials, as if someone knows who they're texting. And then we have this conclusion, unknown why he came to the conclusion, but the conclusion nonetheless by the police officer that they were originated with Miss Fry. Now, that didn't result in any charges, which is obviously a good thing for Miss Fry, but that could be for a whole variety of reasons. From the perspective of the prosecutor's office. And as I said, their standard is a bit higher. They have to determine that there's probable cause that a crime was committed, which is a higher burden than what is in a civil case, is these protective orders, which only require a preponderance of the evidence, that is, some evidence. And when I'm reviewing another judge's decision, basically I have to make a determination of whether there was any evidence that could support his conclusion. And I believe that there was evidence that could support Judge Lieber's conclusion here. Thus, I'm not in a position where I could overturn his decision. So I'm going to leave his decision in place. Now, that leaves this protective order in place until April 24th of this year. I will make an exception for any, school ordered events. That is, an event where the school directs the parent to appear at the freshman campus. If you need to appear for your son, I usually say I don't want to interfere with kids' school. I don't want to prevent people from working with protective orders. However, all other occasions you should stay separate from each other, because, like you say, it's clear that there is ongoing conflict. Understandably relates to to past relationship, and but it seems like both of you are places where you could move on from it, and the protective order simply gives you a cooling off period to do that. I will note that on the 24th, assuming there aren't any additional claims of violation during the pendency of the protective order will expire. Miss Beck can apply to extend it at that point, but the standard for extension is you have to show there's some basis for that. That is, the person, the respondent is continuing to engage in some conduct that at least raises the threat of a violation of the protective order, if it's not an outright violation of the protective order. And I'm not seeing that, and Ms. Beck hasn't filed any allegations. This entirety of this litigation has been attempts to dissolve the protective order that Ms. Beck put in place. She hasn't filed. Usually in a case where someone is out to get someone via a protective order, after the protective order is in place, I see a slew of violations, and I haven't seen that here. So, this will run its course in April, and it's possible that at that point, Ms. Beck will feel like, oh, this is over and done with, and not feel the need to renew it. If she does, she has to provide separate proofs in addition to the proofs that supported the protective order, and then you get another opportunity for me to decide, or perhaps a visiting judge, kind of depending on how fast we get it on the docket, to decide whether or not the order can extend or not. And usually, actually, those come to me, so that'll be my decision in April. So I'm going to leave it in place until April. The exception, Mr. Van Heuvel, if you would send me a revised order, same expiration date, with the exception allowing Ms. Fry to attend any school directed events, and that would be, along the lines of, the freshman orientation. Very understandable that, occasionally there's a parent meeting or something like that you have to go to, and, Ms. Fry should be able to attend if the school is asking parents to attend those events. With regard to sporting events and the chance for an accidental encounter, because after all, you two live close to each other. Kids do go to some school events together, not at the same school, I understand, where Ms. Beck works. I always tell people, if you do have a chance encounter and you turn 180 degrees and walk away from the other person without a word, me as the judge, I'm not going to say, boy, you were looking to violate that order. So you don't necessarily, Miss Beck's son's not wrestling, is in the anime club. You might be in the same building, but my observation is that the wrestling room and anime clubs are usually quite a distance away from each other, and any meeting would be along the lines of, maybe we saw each other in the parking lot or something. And like I say, if you kind of turn and walk the opposite direction, like it sounds like the both of you should in a situation like that, there's not going to be a violation there. The only violations are when someone decides they for whatever reason want to engage the other person, kind of take it to a new level. So in my mind, protective orders, they used to be called peace bonds. They're designed to keep the peace. They're not designed necessarily to, limit anyone's life or ability to do things. So that's what I'm trying to accomplish here through that modification of the order, is to allow, Ms. Fry to attend to her kids' reasonable required school events and appearances. If he's going to be a freshman next year, there may be some of those at the freshman campus. I have attended several for my own kids here in East Grand Rapids, so I have to assume that similar things happen in Kentwood. So I will allow that to happen, but the remainder of the protective order will stay in place until April the 24th.
Thank you, Your Honor.
Thank you, Your Honor. Your Honor, you have an initial order already on this file. The other isn't checked yet. You could have your secretary simply check it for you. Lisa could, I'm assuming.
Sure. Yeah, we can do that. And then fill in the language you'd like.
Yeah, no, that's what I'm planning to do. I'm just letting you know that I'm going to take.
That sounds, that'll work for me.
Okay, thank you, Your Honor.
Very good. And send a copy of it, of course, to, Miss Beck, when you send it to me, and she'll know that it's going to get my signature, so she'll know what's going on there.
Yep, exception for the school events and extracurricular through the Kentwood Public Schools.
Correct.
Thank you, Your Honor.
Thank you very
Thank
much.
you.